Hello, everyone. I'm Keith Cooper-Schmidt, the CEO of the Copyright Alliance. I want to welcome you to part 2 of our Copyright Academy discussion of filing a claim with the CCB. You may recall in our part 1 of this video, we had Terica Carrington, Vice President and Copyright Counsel for the Copyright Alliance, discuss things like the type of claims that can be brought before the CCB, who can file claims, and who can be sued. Okay, now we're lucky enough to have Terica back with us today to talk about other issues relating to filing a case. Things like fees, copyright registration, and maybe most importantly, the type of information that you need to include when you file a claim with the CCB. So Terica, welcome back. Let's start today's discussion by talking about fees. We had a separate video going through a lot of detail about fees, but now we're just going to talk about fees having to do with filing. So what is the fee that a claimant must pay to bring a claim before the CCB?
The total fee to file a case with the CCB is $100, which is hundreds of dollars less than the fee to file a case in federal court. The CCB filing fee is actually split into 2 separate payments, a first payment of $40 and a second payment of $60 for a total of $100.
All right, so I think that's pretty simple, but if anybody wants more of an explanation, like I said, refer back to our video on fees and costs for that. Now let's talk about copyright registration. And we also talk a little bit about that in that video, not much, but a little bit. When you bring a case in federal court, as opposed to the CCB, you must register the work with the US Copyright Office beforehand. My question to you, Terica, is that also true with CCB cases? In other words, does this copyrighted work at issue in the CCB claim need to be registered with the Copyright Office before the claimant can file a claim? And if so, what should the claimant do if they haven't registered their work and they want to file a claim?
So in order to bring an infringement claim or counterclaim before the CCB, the copyrighted work that is the focus of that claim must be registered with the Copyright Office, or a registration application must be pending with the Copyright Office. In some cases, the copyright owner will have already registered the work well before bringing the infringement claim or counterclaim. But for those who have not yet submitted a registration application for the work, they can submit their application to the Copyright Office immediately before filing their claim with the CCB. Additionally, if the claimant wants to have their registration application processed quickly, they can request expedited registration through the eCCB system and pay the accompanying $50 fee. The Copyright Office will make their best effort to complete the expedited review within 10 business days. And any claimant that wants to expedite their registration should be mindful of 2 important things. 1, this request can only be made once the case becomes active. So in other words, after the 60-day opt-out period ends and the respondent has not opted out. And 2, the request must be made through the eCCB system and not the regular Copyright Office registration system.
All right, that's very helpful information. So we talked about registration, we talked about fees. I think it's now time to go through the dreaded information about how do we actually file a claim, right? So now let's do a deep dive into the actual process of filing a claim with the CCB. My first question, Terica, is when a claimant files a claim with the CCB, what type of information should be included in that claim?
Thankfully, the CCB makes filing a claim pretty easy by providing a fillable claim form that specifically requests all of the necessary information. So some of the general information that will be requested includes the type of claim, the name and mailing address of the claimant, the name and address of the respondent, whether the claimant requests that the proceeding be conducted as a, quote, smaller claim, which would have a limitation on total damages of $5,000, and a certification under penalty of perjury that the information provided in the claim is accurate and truthful. And then in addition to that, there are also specific types of information that will be requested depending on the type of claim being brought.
Right, well, that wasn't so difficult. I was really worried this might be complicated or something. That doesn't sound that complicated, but we're not done, right? You mentioned at the very end of your answer there that the specific information will also be requested, and that information depends on the type of claim that's being brought. So let's walk through the 3 types of permissible claims again. Let's start with an infringement claim, and I'm going to ask you what type of information is required for an infringement claim.
So for an infringement claim, the claim form requires information such as information about the work at issue, including the title of the work's authors, whether the work has been registered or registration application has been submitted, and the work's authorship category or a description of the nature of the work. Also, a description of the facts surrounding the infringement and a statement describing the harm suffered by the claimant as a result of the infringement and the relief sought by the claimants. And that statement may, but is not required to, include an estimate of any monetary damages sought.
All right, so that's helpful. That's a little bit more detailed, but certainly still something I think claimants can easily handle. So let's move on to the second permissible claim, declarations of non-infringement. What type of information is required for a declaration of non-infringement?
For a declaration of non-infringement claim, the claim form requires information such as a description of the controversy or dispute between the parties. So for example, the other party may have threatened to take action to enforce their rights, such as in a cease and desist letter, or sent a DMCA takedown notice. The claim form is also going to require information about the work at issue, if known, including the title of the work, whether the work has been registered or a registration application has been submitted, and the work's authorship category or a description of the nature of the work. The claim form is also going to ask for a brief description of the claimant's use of the work at issue and a brief statement describing the reasons why the claimant believes that no infringement occurred.
Okay, so let's take on now the last, or not really last, the third type of permissible claim, which is a misrepresentation claim. What type of information would be required to file a misrepresentation claim with the CCB?
So for a Section 512F misrepresentation claim, the claim form requires information such as a description of the takedown notice, including the sender and recipient of the takedown notice, and if known, the date the takedown notice was sent. If a counter notice was sent, a description of the counter notice, including the sender and recipient of the counter notice, and if known, the date the counter notice was sent. The specific words used in the takedown notice or counter notice that are alleged to constitute a misrepresentation, and an explanation of how and why those words constitute a misrepresentation. And finally, a statement describing the harm suffered by the claimants as a result of the misrepresentation and the relief sought by the claimants. That statement may, but is not required to include an estimate of any monetary damages sought.
Okay. Now, we talked about the information that a claimant needs to provide when they file a claim, but there may also be documents that a claimant might want to include along with this information. It could be a contract, could be a copy of the copyright registration, maybe. Can you discuss the type of documents a claimant might want to include with the claim that they are filing?
Yeah, so the claimant can choose to include additional files and attachments that they believe play a significant role in setting forth the facts of the claim. And those might include a copy of the copyright registration certificate for the work at issue in the proceeding, a copy of the copyrighted work itself alleged to be infringed. That can include a hyperlink or screenshot that shows where the allegedly infringed work has been posted, a copy of the allegedly infringing material, including a hyperlink or screenshot that shows any allegedly infringing activity. For a misrepresentation claim, a copy of the notification of claimed infringement that is alleged to contain the misrepresentation, or a copy of the counter notice. For a declaration of non-infringement, a copy of demand letters or other correspondence that created the dispute, or anything else that plays a significant role in setting forth the facts of the claim.
All right, so I'm a claimant. I feel real confident now. I got my information. I know what I'm gonna kind of provide to the CCB in terms of information. I've got my documents already, so I know what I'm gonna provide. So I'm all ready and I'm raring to go. Okay, and I'm ready to file my claim with the CCB. But how do I do that? In other words, if I'm a claimant, how do I submit the claim? Is there some website I go to? Do I email the CCB? How do I do that?
Yeah, so there is a website. In most cases, the claimant is required to submit the claim and accompanying fee through the electronic filing and case management system, which is called the ECCB.
All right, that sounded really, really simple. I had a long question there, but a simple answer. That's wonderful. I love when that happens. So after the claimant submits a claim to the CCB, then what happens? So they're done, right? Or I don't know. What happens next? They submitted it. What should what should the claimant expect next?
After the claimant files their claim with the CCB, a copyright claims attorney examines the claim to make sure that it meets all the requirements of the CCB. If the claim is found to comply with all the necessary requirements, the claimant will be notified and instructed to serve notice on the respondent. If the claim does not meet the necessary requirements, the claimant has 30 days to amend the claim so that it does comply. Now, if the claimant fails to amend a non-compliant claim within that 30-day period, it will be dismissed without prejudice. If, on the other hand, the claimant does amend the claim within the allotted time, but the claim still does not comply, the claimant is given another 30 days to further amend it. If the twice amended claim still does not comply, the claim will be rejected and the proceeding will be dismissed without prejudice.
Okay, so at the beginning of your answer, you mentioned the copyright claims attorney, and if the copyright claims attorney is going to review the claim and kind of go back and forth, you get it amended, get it in proper form, if you will. So what are they looking for? What's the copyright claims attorney looking for when they are reviewing these claims?
Yeah, the copyright claim attorney is really reviewing the claim to ensure that it meets the requirements of the law and any requirements established by the Copyright Office's regulations. The goal of the compliance review is to make sure that the claimant has stated a claim that is allowed to be heard by the CCB and that the claim, as stated, provides enough information so that the respondent understands the claim against them and can make an informed decision as to whether to participate in the proceeding or opt out.
Okay, so the copyright claims attorney is going to review this and say this is not in compliance, this is in compliance, whatever. Does that mean that they can give legal advice of some sort? Can they, claimant rely on the copyright claims attorney to give them legal advice while they're reviewing this, or is that not permissible?
So even though the copyright claims attorneys are obviously attorneys, one thing that I'd like to always highlight here is that they're not your attorneys. They're not the party's attorneys. So the answer to your question is no. The copyright claims attorneys cannot give legal advice, but they can provide information and assistance to help people understand the procedures and requirements of the Copyright Claims Board.
Okay, so I think we're almost at the end of the process then, right, about filing a claim. So I've got one last question for you. Once the claim has been approved by the copyright claims attorney, other than celebrating, right, balloons, whatever, because you've started your first CCB case, right? What are the next steps for the claimant?
So if the claim complies with all the necessary requirements, the claimant will be notified and instructed to serve notice on the respondent. And we actually have another video that goes into detail on how to serve notice. So check that out for more information.
All right, so I think we've covered everything we want to cover in filing a claim. People may have additional questions, but we've definitely covered a lot of ground here. So thank you, Terica, so much for helping us out here and helping all these prospective claimants understand how to file a claim. And hopefully after watching both part one of this video and this video, part two, on filing a claim, prospective claimants will have a better idea of what file a claim with the CCB entails and how to do it. But in the event you are watching this video and still have some unanswered questions about the filing process, you can go to the Copyright Alliance CCB Explained page on the Copyright Alliance website, or we have a hotline. So you can call our CCB hotline at 888-5403-CCB. So that's 888-5403-CCB, and you can get more information. You can ask your question. Now, the people who respond to those hotlines, they will not be giving you legal advice, but they can provide you information or provide you with resources and things like that where you can get your questions answered without giving you legal advice. But in addition to the resources the Copyright Alliance has, you can also check out the numerous resources that the Copyright Office has on its website. And so you want to go to ccb.gov, that's ccb.gov, and the Copyright Office has an abundance of materials, especially a CCB handbook that you might find to be extremely helpful. So with that, we're going to wrap things up. I want to thank you again for watching. And I want you to keep an eye out for future videos about the CCB process, because what we're going to do, as Terica mentioned, we've got other videos to talk about the rest of the process. We're going to have some videos talking about specific subject matters too, like in discovery and whatnot. So we're going to be producing quite a few videos here to help guide you through the CCB process. So thanks again for watching, and see you at the next video.